And since this is a religious-based organization, we do start with a prayer. So let us pray. Dear Lord, we come to you for guidance and support. Please provide us with the wisdom and clarity we need to make the right decisions. Give us the strength and courage to face whatever comes our way. We trust in you, Father, Son, and Holy Spirit, to guide us through these confusing times. Amen.
Amen.
Okay, and we have learned a great deal about Rebecca in the beginning of the conversation, but let me just introduce her a little more with regards to what we're going to talk about this evening. Rebecca is a partner with the law firm of McCabe Mack in Poughkeepsie. Her practice is concentrated in the areas of estate planning, guardianships, trust, and estate administration and elder law. She's a member of the National Academy of Elder Law Attorneys, the Hudson Valley Estate Planning Council, the Dutchess County Bar Association, the New York State Bar Association, and the Mid-Hudson Women's Bar Association. Additionally, Rebecca has served on many committees and boards for not-for-profit organizations in Dutchess County, and we're so happy to have you here tonight.
Well, thank you. Thank you for inviting me. Does everybody want to tell me who they are? Just since it's a small
Sure.
group.
I'm Dave McNary. I'm one of the wardens at St. Margaret's in Strasbourg.
Yeah, I'm Burke Chandler. I'm another warden at St. Margaret's with David.
Nice to meet you both.
And I'm Marilyn Kirchner, and I'm a treasurer at St. Paul's in Pleasant Valley.
Excellent.
I'm Kathy McNary. I go to St. Margaret's. I'm a retired English teacher in high school.
Very nice to meet you all.
And I'm a warden at St. Paul's, so.
Wonderful. And to my neighbors, did you guys know John Blahut?
Oh, yeah.
Yeah, he worked with us too at McCabe Mack prior to Jean. Yeah, I missed him.
Barbara, yeah.
So my birding buddy. Okay, so we can do this one of two ways. I can sit here and give you guys the Trust and Estates lecture, which I'm happy to do. But also because we're a small group, I'm happy to kind of survey you and find out what it is you're interested in hearing most about, and we can kind of tailor make it more of a conversation than a lecture. It's your choice as to how you want me to proceed with this. I'd love your input into what you guys are really concerned about.
One of the questions I have in my mind is what should Kathy and I both be thinking about at this point in terms of getting, I guess, do we have things in order that we should have in order? Are there things we should worry about, and how do we go about that?
Okay.
My biggest question is, when do I need to call the lawyer and when can I do something myself? That's like my biggest, I don't want to mess something up. So I know that there's a lot of things that probably you'll cringe when I say, like LegalZoom and all those things that online you can find things, but should you use them? So.
Excellent question.
Mm-hmm.
Marilyn?
Well, I have a will, of course, but what more do I need to do?
Okay. All right.
Yeah, I have a will, and all of my investment accounts are held in trust for my wife and my two daughters.
Okay.
And one of the questions that I have is 47 years ago, we bought a house in Hyde Park, and my wife and I are the co-owners of the home, and the home is currently free and clear. And I'm wondering if there's any advantage in adding one or both of my daughters to the deed of the house.
That is an excellent question.
Whether that makes any sense or not.
Yeah, excellent question. All right, so we'll cover all of that, and we'll kind of delve in and just raise your hand, interrupt me as we go. Again, small group, so it's nice because we can be intimate with the conversation and keep it as a conversation. So starting with the word LegalZoom, yes, I cringed. Speaking from experience, we have spent our clients have spent a lot of money. Or I should say clients' families have spent a lot of money cleaning up messes that were made from LegalZoom. So it is one of those things, don't do your own surgery, don't do your own stitches, maybe see a lawyer for the legal documents. People cringe at law firm prices, but we're happy to have conversations at the front end about what things will cost and price ranges and things like that. A fee up front to get documents that that you and your family can rely on is very important. And there's things that people just don't realize are options. We've had clients disinherit children with disabilities when they could have done a supplemental needs trust because they thought the money would kick the child off benefits, or I gave everything to this child to hold for everybody else and split things up. And there's things your lawyer can advise you on that you wouldn't necessarily think about because they're used to seeing different situations, and we can make recommendations of things that might fit you. So when to see a lawyer, you should see a lawyer at least once at some point in your life, be it already or coming up, to look at to do a legal checkup and just look at your documents to make sure everything is still in good order and what you need. The since this is a religious group, the trinity of documents, as we like to refer to it, is the will, healthcare proxy, and power of attorney. And nobody escapes my office without all three. So the power of attorney and healthcare proxy are pretty much simpler. Power of attorney is not a simple form, but if you're working with an attorney that uses them all the time and drafts them all the time, it's a form. And we can put that together and the healthcare proxy together pretty much as just part of the package. We don't really bill for that. It's just the will that you're going to pretty much pay for.
Can I quick interrupt about the
Yes.
power of attorney? If you really meant about just asking, if you, for example, I would give David power of attorney over my assets right now, but can you put a secondary person on if David's
You
incapacitated?
can put a second, third, fourth, and fifth. You can put co. You can
Okay.
put to act in the order named. Yes. And it's very important. A lot of times people think, well, I don't need a power of attorney. My spouse is on all of my accounts. So is everybody familiar with what a power of attorney is?
Mhm.
Yes.
Sorta.
Okay. Sorta.
I mean,
Give us
Yeah.
a short version of it again.
I look at it as before, during, and after. So before you get sick or as you're starting to decline, the power of attorney kicks in to do things for you that you could do normally for yourself, but you're unable to now.
Mhm.
The healthcare proxy living will is towards the end, and then after the fact we have the will or the trust. So a healthcare proxy is exactly what it sounds like. That's somebody to make your medical decisions for you if you can't for yourself. The power of attorney is everything else in your life other than healthcare decisions. So it's everything from banking, which yes, most of us, my spouse is on all of my accounts. I'm on all of his as far as I know. So we can do our banking, but he's not on my 401k and I'm not on his 403b because those are individual accounts. They don't even like talking to me when I call. They're not going to talk to him without a power of attorney. Same with things like signing tax returns for each other. If I'm incapacitated and he needs to file our annual tax return, if he needs to do health insurance billing transactions for me because I'm sick, he's not going to be able to talk to my health insurance company. So the power of attorney really comes into play with all of those things. It also comes into play with real estate. Burke, I'm going to get to your question in a little while about the house and having the kids on the house.
Mhm.
But if an event comes up where somebody needs long-term care and we're looking to get Medicaid to pay for those costs, we can put the house in the well spouse's name and get the ill spouse on Medicaid sooner and protect the home for the well spouse. With a properly drafted power of attorney, we can transfer the house to the well spouse. So the power of attorney is very, very important. And, there's more positive situations, such as when COVID was first announced or, put out there and we had the shutdown, we had citizens that were traveling and got stuck abroad for a couple weeks. If you had a closing scheduled for your home, if you had to file a tax return, if that was right before April 15th and they hadn't extended the tax deadline, your power of attorney can step in and do all of that for you while you're gone.
Mm.
So it extends to other scenarios. If you're temporarily incapacitated, it does go in effect when you sign it. So you have to give it to somebody you trust. And your agents have to sign accepting it. So what we do a lot of times is have the spouse or the primary agent sign, but we don't have the alternate sign unless they need to.
Well, what if for Kathy and I, we have the power of attorney of each other, but let's say we're on a trip and we have,
You already answered that.
okay, well, we have one of our children as a power of attorney.
Yes. Then your alternate can make the representation that the agent's unable to act and they can act for you.
Okay. Okay.
So yeah, absolutely. And with the alternates, if you decide to pick 2 children, you want them to be and I have that a lot. There's only 2 kids. It's a, cohesive, happy family. Nobody wants to be excluded. We can put both children, but there's a place where you can initial that says you can act separately.
Okay.
So you don't have to co-sign everything. You don't have to be at the bank together. They can act independently of one another. So you can, otherwise they're forced to act together. I really advocate against that. That's a nightmare for everybody involved, especially with the way, families are spread out across the US right now. It's tough when you make them act.
Exactly.
So that's the power of attorney. I personally, doing elder law work the way I do, and I have to bring guardianships every now and then when there isn't a power of attorney in place and somebody gets sick. The power of attorney is almost more, unless there's special circumstances with a will where you're trying to protect assets for somebody in a trust. The power of attorney is almost the most important document we do, because if you're incapacitated, what do? How do we help you? And a well-written power of attorney saves your family so much angst and will ensure that you're going to be taken care of. So that's the power of attorney. The other one is the healthcare proxy. There's a healthcare proxy that's just a plain healthcare proxy. Now this one you can do yourself online and you don't have to pay LegalZoom. You can go to the Department of Health website for New York State. Just Google New York State Department of Health healthcare proxy. There's a model form. The healthcare proxy form you can fill out. You can have 2 people sign it as your witness. For our clients, we draft a living will healthcare proxy. It's all in one document. Some law firms do 2. So if you've done your documents and you have 2 different documents, that's perfectly fine. But the living will takes the healthcare proxy a step further. And ours says in particular, it doesn't address terminal conditions. What it addresses is if you're going to have a permanent lack of capacity due to brain illness, disease, deterioration, injury, and you're not going to regain your cognitive function. In that event, like I have one of these, in that event, I do not want extreme medical means to be applied. And if they are, you can stop. If I'm not going to regain my capacity, no matter what's done, and 2 doctors have said that. So that takes into account, and it might not be terminal, but if I have a bad stroke and I'm not going, there's no brain activity, I don't want extreme measures. If I have advanced Alzheimer's and it's discovered, like with a lot of my elderly female clients, they get breast cancer, are we going to, do a mastectomy and chemotherapy to somebody in advanced Alzheimer's states? And that's what the healthcare proxy living will can address for you. You can also put on the form from the state if you want. There's an area where you can say my agent knows my wishes, or this is what I would or wouldn't want.
Yeah, isn't there a term do not resuscitate?
So that's an interesting question in and of itself. A DNR is a doctor's order. And so what the healthcare proxy does is it authorizes your agent to sign the DNR with your doctor. Because you can't draft your own DNR. The doctor has to do it and recommend it and say it's okay, but the patient has to sign agreeing to it. And if you can't do that for yourself and the conditions arise where you're not going to, come back mentally, then the agent is authorized to sign a DNR. And there's also, just to throw this out there for education, there's something now that New York has called a MOLST. Have you guys heard of this?
I have.
It's a medical order for life-sustaining treatment. And I love the MOLST. It looks like a pamphlet. It's like a booklet. And it goes through all of the different options for end-of-life care, such as intubation, nutrition, hydration, resuscitation, everything like that. And you can check off, I always want this, I never want this, I want this temporarily to see if my condition improves. And it's a really great form. The doctor signs it, and then the patient who's been through it with the doctor, usually you go through it with the nurse, and then the doctor signs it as well.
And it's called
MOLST, MOLST, or Medical Order for Life-Sustaining Treatment. But if you Google New York MOLST, that form will come up along with the instructions. My concern about the MOLST, and I'm hoping the bar is going to notice this and say something soon. I've had a few clients come in with that form lately. The problem with the MOLST is it's really designed to be a palliative care tool when you are, declining and on your way out. And even the instructions, because I have a client that volunteers with hospice, and she came in with it the other day, and she's like, they rave about these. And I said, well, yes, for hospice's clientele, those are very good forms, but it says right at the beginning, this is designed for people who are anticipated to face, the end of life in a year or two, or are on palliative care. It's not really for the rest of us. So just use caution if you sign a MOLST that, they will not treat you if they find that in your file. So my recommendation is that you make it known to the person that's your healthcare agent or your spouse, because if you don't have a healthcare proxy, your spouse can make decisions for you if you're in a hospital, but only a hospital setting or nursing home setting. You make it known to your agent, I would want a MOLST under the proper circumstances. Your agent, as your healthcare agent, would have the authority to sign the MOLST for you if you can't. But it's designed to be a self-directed tool.
Yeah, I would think the hospice or the hospital would offer that to you.
Yes, they do. But I'm starting to see people come in where their doctor's offices have given this. And I'm like, wait, this is not, So if you hear of a friend talking about the MOLST, point out the first paragraph to them and just say, are you really sure you want that? Or it would be better for you to sign a healthcare proxy that somebody can sign that form for you at the right time. So it's a great form. I mean, it really is, because, who wouldn't want something to be tried temporarily? But beyond that, it's out there a lot. So if you're seeing people with the MOLST, tell them to take caution and be careful with that form.
I'm sorry, what are the initials again?
MOLST.
Okay, I've not heard of that before. Okay.
Yeah.
Because you haven't needed it. I mean,
right. Exactly.
I was the POA for my aunt and her healthcare proxy, and she had she had Alzheimer's, and when she went into hospice, I signed the MOLST for her. But
that's exactly how it should have played out.
Yep. And then it was always have that form always with you, and she got no more trips to the hospital, no more ambulance calls. She was at home receiving the palliative care.
Did the hospice offer that form to you?
At the hospital, yes. The hospice interfaced with us at the hospital and explained everything and brought the big green booklet. And
it was probably a hot pink form or something really bright. Usually.
You can't miss it.
Exactly. So, but it is a good form. So that's out there. But your healthcare proxy would have the authority to do that for you. So those are, the two, we call those advanced directives, my power of attorney and healthcare proxy. If I can't act for myself, I have these advanced instructions and agents picked out to do things for me. On your healthcare proxy, we can name multiple agents, but they have to act one at a time for obvious reasons. The physicians don't want multiple people being able to make decisions, and then they start fighting or countermanding each other. So we start, usually with the spouse, and then we name children in the order named. And it doesn't, my advice is it shouldn't be birth order. It should be order of calm, cool, collectedness. Who's going to respond? Who's going to be there?
Right.
Just because they're the oldest, if they get, frozen with panic or histrionic, that might not be the best person for the job. And you really need to, it's not a pleasant position to be in. Rita, I'm sure you can elaborate for days about what kind of work it is to be somebody's healthcare agent and power of attorney. So you got to pick somebody that's gonna, even if their feelings are hurt, you got to pick the right one to make the decisions and follow through on things. Because I have seen my clients be put through a lot that they wouldn't have wanted, but their kids couldn't come to terms with the decision that they had to make.
Mhm.
Can I ask a question?
Please.
If you have the healthcare proxy, do your kids have to follow your wishes, or can they change?
They can they're in control, and the healthcare proxy puts them in control. They don't necessarily have to follow your wishes, but there will come a time where the medical team will intervene if they have to. And if they're taking things to the extreme and it's not what the healthcare proxy represents, they will ask them to go to the, the ethics committee or whatever review committee to explain why it is that they're not following the healthcare proxy.
Okay.
There is a way to remove the healthcare proxy and have the next one step up if need be.
If you have children who are lawyers and children who are not lawyers, is it better to have the children who are lawyers or not lawyer? It doesn't matter.
I have colleagues that when I was hired at McCabe Mack, I was hired in the litigation department. And I have colleagues who are now my partners who said, you want to go work with, dying and death. And how can I can't even go to the hospital. I can't even go to they're lawyers. They're great lawyers. It's not their area. You want the person that is the right person. Keep in mind, it's your healthcare. So if there's a declining situation where, it's not death is imminent, but you're going to decline for a while. There's a lot of doctor's appointments involved. There's a lot of care coordination. There's a lot of calls to pharmacies and things like that involved. You want the child that's going to show up, the child that's going to answer their phone and be there, the one that's going to make the strong decision. And I've even had people not appoint their spouse because they know their spouse can't handle it. They say, you know what, I'm going to put my daughter in this situation because my husband will fall to pieces and never do what I'm asking him to do. So it's really based on the personality and who you think can do it. And I also have parents where one appoints one child and one appoints a different child. Sometimes there's 3, 4, 5 children. It's not that you have a favorite, but there's a personality connection with some of your children over others. It's not that you love the others any less. There's just one that you might click with. Just, it's a personality thing. They might appoint one and one might appoint another. I've had fathers appoint sons and mothers appoint daughters. It's a personal decision, and it really is based on what the agent would do. So
Makes sense.
yeah, and we put phone numbers on the healthcare proxy. So the world is flat now. If your child's in Boston, it's okay. As long as they can answer the phone and will answer the phone. You don't want the kid that'll only text. You want the one that'll answer the phone, because some of them don't. So that's the advanced directives. The other documents that we work with clients a lot for are wills and trusts. And most people don't know the difference between the two unless they've already been through the process of creating one or the other. Are you guys familiar with trusts and with wills, or?
Why don't you explain the trust?
Okay, so everybody knows what a will is. So a trust, I refer to it most commonly as a contract. And well, let me back up. There's many types of trust, but there's 2 ways of creating a trust. One is called a living trust, or an inter vivos is the technical name, trust. The other is a testamentary trust. So a testamentary trust is created under your last will and testament. So that takes place after death. That's typical with people with young children. If you did a will when your kids were little and everything got held in trust for the kids until they were a certain age, but the trustee could pay for college or medical expenses or whatever, that's a testamentary trust. The other type of trust is a living trust. And of living trusts, there's revocable and irrevocable, which is exactly what it sounds like. Irrevocable, you put something in that trust, it's not coming back to you without moving a mountain. A revocable trust, you can take back, you can change, you can amend, you can restate the whole thing until you take your last breath, or if it's a joint trust between you and your spouse until the second of you passes away, the trust can be amended or changed. I look at the living trusts as a contract. It's a document. They're usually, ours are shorter because we just keep them simple. Some of them are very long with tables of contents. It depends on your attorney. And it could depend on the complexity of your assets. If you had those types of assets, you probably would have attorneys in New York City who have already set up the trust for you. So we do pretty, I like to draft trusts that I know my clients understand what they're signing. So we keep them pretty simple. Ours are usually between, like I said, 6 to 10 pages, depending on what it is. And there's always a person that creates the trust. It's either called a grantor or a settler. Those terms are kind of used interchangeably. That's the person who's the client. It can be husband and wife. It can be siblings. There can be more than one person setting up the trust. But the grantor sets up the trust, and you pick a trustee. If the trust is revocable, you can be your own trustee. If the trust is irrevocable, for most irrevocable trusts, you're not your own trustee. You're picking a child or a spouse or somebody that you trust, who you trust to be the trustee. And then the trust document itself governs you end up giving assets to your trustee, your house, a bank account, an investment, a life insurance policy. You put the asset in trust, you retitle it to the name of the trustee, but as trustee. So if my aunt does a trust and she names me as trustee, she's going to retitle something to me, but then it'll say as trustee of the trust under agreement dated April 27th, 2023. So what that denotes to the world is it's not mine personally. I'm kind of the CEO, for lack of a better word, of this little trust world. I hold that asset, but it's subject to what the trust tells me I can and can't do with it. And then the trust document, the rest of it is instructions. So, for instance, if we're doing a revocable trust, it might say, my husband and I are creating a trust. We're our own trustees, and we're deeding our house to ourselves as trustees. We have the right to use that house for life. If there's any income generated, comes to us. We can sell the house and invest the money, and the money comes to us. We can sell that house and buy another house, and it's during our joint lifetimes, and it's revocable. We can take it back at any time. At the death of the second of us, this is what happens with that house. And it could be that the house gets sold. A lot of times I like to direct that if it's not a family home that people think a child would want, like a lake house or, a house that everybody grew up in and they intend to keep the house. We usually direct that the house be sold. So there's no complaining back and forth between the beneficiaries who now technically own the house. You like to say the trustee takes care of this because otherwise delays happen. And then it says the house will be sold, and then the balance is split up as follows. And it could be to the kids in equal shares. If one of them dies before me, it goes to my grandchildren. It could be, I want 10% to go to my church. 10% to St. Jude's, the balance to my nieces and nephews. You can do that any way you want upon death. And so the kicker is whatever's in that trust at your death does not go through probate and through your will. It has its own ownership. It's a non-probate asset, and it passes per the trust agreement at death.
Is that the major advantage of putting it in trust?
Yes. So there's a couple of advantages depending on which type of trust you use. The revocable trusts, 99% of them are done because it doesn't go through probate. It avoids probate altogether. And are you aware of what probate is? People hear that word, but they don't really understand what that entails. Or
But doesn't mean that it goes to the state to decide how the assets are.
No. What probate is when you draft a will, it's your last will and testament. But that will could have been fraudulently done. You might not have capacity. It might have been your nurse that at the very end had you sign disinheriting your family. You might have been promised something like, Dad, sign this over to me in the will, and I'll take care of you when you're old. There's different ways of fraudulently inducing somebody to do a will. So what happens is the will has to be presented to the surrogate's court for the judge to say this is valid. And it's not, the end of the world. In cohesive, amicable family situations, let me back up. The people, when we go to probate a will, we have to file a petition with the will in the court. And anybody that would have inherited if there wasn't a will gets notice of the probate, because those are the people that would benefit if that will got thrown out. So what would happen is we would go to court with the will and the petition, and in a good family situation, the kids have already signed off on the will. Even if there's a spouse, we still have to give notice to the kids. Everybody signs off, they consent, we file everything with the court, and within a few days we get the executor's certificates. It's a certificate from the court called letters testamentary. And that says you're in the driver's seat, you're the executor because the will is valid, go do what you need to do.
Do all wills go through probate?
No. So, these are great questions. So what happens is, usually upon the death of a first spouse, when there's a surviving spouse, we don't have to probate because your house is jointly owned. The spouse can transfer one vehicle to themselves as long as it's worth less than $50,000 or $30,000. You can transfer a vehicle to yourself. You can also collect with a death certificate anything that you're a joint owner or a beneficiary on. So typically upon the death of the first spouse, everything is set up to cleanly pass to the surviving spouse.
Right.
It's the death of the second spouse where it comes into play with the home was just in the surviving spouse's name by operation of law. The bank accounts were never updated to put the kids on as beneficiaries, things like that come up, the vehicles. So you had a question?
Yeah, if you have two separate 403Bs, if one spouse dies, how is that handled?
There should be a contingent beneficiary on the account. So we always advise surviving spouses to double check all their beneficiary designations. What typically happens is you have your spouse as beneficiary and then you have the kids as contingent. So if you don't update when the spouse passes away, the kids just have to present both death certificates to say, Mom passed away, Dad was the Benny, but he's predeceased, so now it vests in us as contingent.
So that's done.
That should be done now. That's homework you should do now, and make sure you have contingent beneficiaries on your life insurance and your qualified.
But I meant if there's a surviving spouse.
Right. So the surviving spouse would inherit their spouse's 403B. And what happens is when you inherit it, it doesn't stay in the deceased spouse's name. It becomes a for benefit account. They roll it over to the spouse. So it would be, sorry, David, we're killing you off first. It would be the David McNary 403 for the benefit of Kathy. And then you would, at that point, set up new beneficiary designations on your account,
Okay.
which would be the kids.
Okay.
And start taking out the required minimum draw.
Yes,
If you
yes.
were
When you
above
attain the
age.
age, they want you to take that draw. If you're under the age to take the draw, you can, if it's a spousal rollover, you can wait until you hit the age.
Mhm.
Well, we wish.
I understand. So did you have a question, Rita?
I do. Going back to trusts.
Yes.
If I wanted to leave my house to the church,
Mm-hmm.
I would do that through a trust.
You could do that through a trust, or you could also do it in a will, a simple will, just saying upon my death, my personal property goes here. I direct my house be sold and the proceeds go to the church, and then the balance of my estate be carved up this way.
Okay, because I just have this weird accounting mind, if I put it in a trust now,
Mm-hmm.
would I be able to put it in the church's name now and then not pay taxes?
No, but you're not going to pay taxes anyway, unless, and if it's one of you, good for you, unless your estate's the estate of either you or you and your spouse combined, because it's one exemption basically, exceed $6.2 million.
Funny.
It's not a big issue for most people.
Okay.
Not anymore. When I first started practicing, it was $675,000. And that adds up. If you take both retirement accounts or the equity in the house and a retirement account, it added up quickly.
Mhm.
Now it's 6.5 million. And federally, it's up to almost 13. It's like 12 and a half, and it's going up. Federal is supposed to be cut in half in a few years. Of course, who knows what Congress does on any day. So that's still, that hasn't happened yet. But even if they cut it in half, it's still going to be the 6.5.
Okay, so it doesn't matter whether I do it in a trust or in
No.
my will. Okay.
And with the trusts we're talking about, both revocable and irrevocable, the way we set them up is that your kids or your heirs will get what we call a step up in tax basis. So if you're in the home that you purchased way back when, and it's worth a lot more now, when you pass away, the kids either out of your estate or in the trusts will get a date of death value in that house. It wipes out all of the capital gain.
Mhm.
Then when they sell the house, they only pay gain on the difference between date of death and the day they sell. So if they hold on to it for 10 years, that's one thing. But same with your stocks and bonds and things like that, they get date of death value.
Yeah, I was thinking, with your investment accounts, if you have the proper beneficiaries named and in trust for named,
Correct.
then I'm thinking
And
that you're in pretty good shape.
you are, and you
Because
do
the
not
proceeds
want co-owners as kids on those investment accounts, because if they're a co-owner, they don't get the step up in tax basis.
Okay.
They
So-
want to inherit it.
So in my case, it comes down to my home being
Right.
the remaining
So
asset. It's
I
in the will.
prefer trusts versus putting kids' names on deeds. We used to, back in the day, put children's names on deeds because it was an easier way to do it, but the trusts have really become the preferred way. And there's a couple reasons for that. One is if you sell your house during your lifetime, the kids are now owners and they don't get the capital gain exemption that you get. We typically do it through a life estate so you can keep your star exemption, but if you did it just as a joint owner, that you don't get the star exemption. To get the star exemption and put them on as a life, you keep a life estate, but you're giving the house to them. If the house does get sold, they get a large share of the proceeds because they're owners. So there's a number of reasons. There's also a creditor concern. If, they have a debt or they get sued for something, your house is their asset.
Mhm.
And then also with a trust, we can direct upon the death of you or your spouse, the house should be sold and the balance be distributed. If you don't do that, the kids become co-owners.
Mhm.
So then they're looking to each other to pay the property taxes and the cleaning out costs. And it's just cleaner to have one person in charge to deal with it. But it's a personal decision too. We still draft life estate deeds every now and then. But a trust is just, a simple way to do it. The other trust I was mentioning was an irrevocable trust. And that's the one that'll get you through, once you get through the 5-year look back period. If your house is in an irrevocable trust, after 5 years, if you need Medicaid care because you need skilled nursing care, the house will be fully protected from that look back period and from Medicaid attaching to the equity in the home.
Is that true with a revocable trust though?
No, because you are your own trustee. So, and you can revoke it. So Medicaid will say revoke it.
Is there a time limit or a time that I've heard of this, if you put it in an irrevocable trust within 2 years of somebody having to go on Medicaid because of
5
years?
5 if it's nursing home care, and they're about to put 2.5 for home care. Yeah. Now,
Okay.
I don't want to panic anybody, and this is a whole nother discussion on its own, and I can do that for for a little while if you'd like me to get into the Medicaid planning piece of it. I can also do another group meeting like this with you guys if you want to just focus on the Medicaid planning. But the 5-year, so with the home, if one spouse gets ill, the well spouse can always hold on to the house. That's not a concern. Especially if you have a good power of attorney. Remember the power of attorney? You have a good power of attorney that lets us transfer the house to the well spouse. It's transfers between spouses don't, get penalized for Medicaid. We can get you on Medicaid with the house and the well spouse's name. The concern becomes if there's only one of you or if you both need care. The concern also comes if the ill spouse outlives the well spouse, and now the house has to go to the ill spouse after death. The irrevocable trust will avoid that. But irrevocable trusts are not for everybody. If you're not planning on staying in your home that you're in, or if you're planning on using, and I say that, but you can sell your home and buy a new home out of the trust, and the 5 years doesn't reset and a new home can be purchased. But some people plan on selling their house and using some of the equity for spending money and downsizing or renting. We can't do that. What's in the trust stays in the trust. All you get is the income, interest in it. You can't take the principal back because then Medicaid could say pay for your care with that.
Okay.
So, so there is a catch to it. But some of my clients say, I'm not leaving my home. I have no intention of leaving my home. And then I have clients say, well, I love my home, but it's like my house, it's on a hill, there's 15 steps up to the front door. I know I can't stay here and age in place with that kind of a home. But they also say, I'm going to move in with my daughter when that day comes. She already has the room ready. You may not want your home in an irrevocable trust. You might want to use that money for your care. It just depends on the client, and everybody's different. So we usually go through and look at your other assets and see, if it's an appropriate arrangement for you. But that's what the irrevocable trust. We use irrevocable trust for other things, but that tends to be the major one for most of my clients who are just doing your average estate planning.
Mm-hmm. My perception is that wills are inexpensive and trusts are expensive.
Not necessarily. We charge by the hour instead of flat fee. I know clients prefer flat fees, but we find that typically benefits the clients because we come in under what the flat fee rate would be, if we just charge you a big flat fee. So I'm expensive. I don't control my own hourly rate. That's a firm decision, but the going rate for partners in Poughkeepsie is between $350 and $400 an hour. And we bill our partners at $375. So that's my rate. I have an associate.
What would be the typical cost of a trust?
So to do a will, healthcare proxy, power of attorney, and a trust is usually between 3 and 5, well, probably about 4 to 5 billable hours. So you're looking at between $1,200 and $1,500, plus the cost of recording the deed with the clerk's office to the trust, which is about $200.
Mhm.
So, and it's a one-time thing. Now, if we have to probate for your house, the average house is going to be, you know, at the top range of the probate fees, and that's $1,250. So it's kind of the same thing. And but the filing fee is the $1,250, plus you have all the attorney's fees involved, plus you've got to keep the estate open 7 months. So it actually is, in the long run, cheaper and more less expensive to do a trust, and it's cleaner for the kids. However, they're paying the probate fees out of their inheritance. You're paying it out of your income and your assets that you've set aside to retire on. So, you know, some people say it's my kid's problem. Some people say I want everything in a trust. I want this to flow easily. And it's different for every client. We don't push documents on people. We just help you find what your goals are and what you really want for ease. But the power of attorney, nobody gets out without. You need a good power of attorney. And, you know, for the Medicaid planning, if a power of attorney is written with gifting powers where we can transfer assets between spouses or to the kids, if somebody is sick and we need to shelter resources, I can usually save about half of your assets at the last minute if somebody gets catastrophically ill and you haven't done any advanced planning. So, you know, start with the power of attorney, if nothing else.
Mm-hmm.
I have long-term care. How does that
Good.
with Medicaid?
So depending on the policy,
Yes.
and if you were my client, I would ask you to bring a copy of the policy to the meeting or get one shortly thereafter. Depending on the policy, that is either going to take a huge dent out of what the daily cost of care is and allow your money to go a lot longer.
Yeah.
Or if it's one of the turbocharged partnership plans, we don't have to do a lot of planning because after the policy pays, you can go right on Medicaid without having to transfer assets.
I have a John Hancock, and I was told it was one of the better ones.
Yes, John Hancocks are usually good. And the thing about long-term care insurance is it's really good for home care.
Right. Yeah.
You know, I have it as a life insurance rider through, you know, something I have with my firm, but we just got my husband the long-term care insurance for the home care.
Good.
I realized I had it and he didn't. I was like, wait a second, I'm going to be the one paying. So we should get him long-term care insurance. But yeah.
When you have a trust, now you
do?
have to each year do a tax return on it.
It depends.
No.
So, and
I work in the tax office part-time.
Oh, there you go.
Yeah.
Which tax office? The IRS?
Eisenhut Brown tax office.
Oh yeah. Okay. So, and I
They
know
do
we're
a lot of
recording this,
trust.
but this is just for parishioners, right? Not the IRS.
Yeah.
Yes.
So what we do with the taxes is if it's a revocable trust,
Yeah.
your social security number is used. All of the income is reported on your income tax return. You don't have to do a separate trust tax return. If it's an irrevocable trust, it will need a tax ID number someday.
Yeah. Yes.
If all we're putting in the trust is a house, we typically just use the grantor's social security number for the trust at the onset, because by getting a tax ID number, the IRS starts pestering us for an annual tax return and there's no income. So you don't want to fight with them every year about interest and penalties for not filing a return on something that's just a piece of real estate. If you're going to put investments into an irrevocable trust, or after the death of the second of you, the house has to be sold out of the irrevocable trust, we have to get a tax ID number, but it's usually not for the kids. If it's just a house and we get a tax ID number, they do a first and final return reporting the sale. There's no income involved. Because it was dated death value that the kids got. There's no gain.
Yeah.
But if there's investments in it and you're getting investment income down the road, you sell the house, you move into assisted living, the money stays there, you get income. If the income exceeds a certain amount, then the trustee has to prepare or hire an accountant to prepare a tax return. It's usually, you know, a few $100s for a tax.
About 400, yeah.
Yeah, for the prep. So, but the income itself gets reported on your tax return as your income. The
Mhm.
trust doesn't pay tax. It just has to file a return.
Yes,
So, yes, very good question.
okay.
Yeah, that's
We're
great.
coming up on the end of the hour. Does anyone have a last question? Or is there a last thing that we maybe haven't hit on, Rebecca, that you'd like to round out the conversation with?
No, I hope I kind of addressed what you guys were looking for. It's
Very good.
a lot of topics in a little bit of time, but I like the conversation
Yeah.
way.
No,
For
this
the
has been
smaller
excellent.
groups.
Rebecca,
This
this
has
has
been
Thank you.
wonderful.
That's
Good.
very good,
Good.
very
And I've
good.
met
Thank
some new
you.
neighbors that I didn't know I had right down the street.
there you go.
My
There you
fellow Episcopalians, so.
There you
Yes.
go.
Good.
It's all right. They're okay. You know.
We are.
Yeah.
All right, guys.
Well, thank you so much.
Thank
This has
you.
been
Yes, it's been
wonderful,
great. And please
informative
come-
and friendly, and
Good.
just the tone of it has been really great. I think we've all
Good.
gotten a lot from it, and we appreciate your time immensely.
Not a problem.
One
If you
thing,
need more
Re-
information.
Yeah, Rebecca,
Noted.
this is, as Rita has mentioned, this is recorded and it's going on our website. If
Mhm.
people want to get in touch with you, what's the contact, the best way?
Should I just hook them up with Paisley?
Yes, I was gonna, Paisley's my my secretary, my legal assistant, and
Legal
she is
assistant.
my gatekeeper, and she keeps my head screwed on. May everybody have a Paisley. Yeah, Paisley, McCabe Mack. We're at 63 Washington Street in Poughkeepsie, in a building we've been in for a long time.
Yep.
We have a website which is mccm.com. Paisley can certainly help you. If you just have a question or a follow-up from tonight, you guys are welcome to email me. If you use email or call me directly, I have a direct line. The direct line is 845-486-6866.
Okay.
And email is rblahut@mccm.com.
Wonderful.
And if you need a meeting, Paisley's the gal, she's the best. And if you do reach out, just make sure you tell me, you know, you were part of tonight's meeting, just so I have a frame of reference, and it triggers my mind, which is turning into a sieve, bigger holes every day. So
This is excellent.
We're the ones.
Really, we really appreciate you coming.
you
Yeah,
got
very
it,
good.
you got it. And if there's more questions, or there's another topic that you think I can help with, or anybody at my firm can help with, or a community resource you need help getting in touch with, just let me know.
Good.
I
Okay.
will indeed.
Thank you,
All right.
Rebecca.
Thank you.
I love this idea. So this is a great group.
Thank
And
you.
please
Thank
tell
you so
Gina
much.
Dell I said hello.
Will do.
Thank
Okay.
you. Bye,
Thank you.
everybody.
Thank you so
Thank
much.
you.
Bye-bye.
Good night. Have a good
Bye-bye.
evening.